And what did we get? Did we get the client list? Did we get the tapes? Did we get the unredacted truth? No. In a shocking filing released quietly to the courts, the Department of Justice, Trump's Department of Justice, led by Attorney General Pam Bondi, made a stunning admission. They confirmed that they have released less than 1% of the files in their possession. You heard that right, less than 1%. But it gets worse. In a move that legal experts and members of Congress are calling a direct violation of federal law, the DOJ has explicitly stated they are asserting common law privileges to withhold documents. Privileges that the Transparency Act specifically stripped away. They aren't just dragging their feet, they are rewriting the law in real time to keep these files buried. Why did the DOJ suddenly discover 2 million new pages of documents days after the deadline? Why were photos of Donald Trump on Epstein's jet posted to the DOJ website and then scrubbed hours later? And why are the very people who screamed "drain the swamp" now the ones building a dam around the most explosive evidence in American history? Buckle up. We are diving deep into the legal filings, the secret letters, and the timeline of a betrayal that proves one terrifying thing. The cover-up didn't end with Epstein's death. It's happening right now in January 2026 from inside the White House. To understand the gravity of this betrayal, we have to look at the text of the law itself. This wasn't a suggestion. It wasn't a request. The Epstein Files Transparency Act was a mandate passed by the 119th Congress with overwhelming bipartisan support. The act was co-sponsored by Democrat Khanna and Republican Thomas Massie, two men who rarely agree on anything, but who united to force the deep state's hand. The legislation was airtight. It stripped the Department of Justice of its usual excuses. Let's look at the text. Section 3, subsection B. It explicitly states that the Attorney General shall make publicly available all records, documents, and communications related to Jeffrey Epstein, Ghislaine Maxwell, and their associates. But here's the smoking gun. The act contains a rule of construction that forbids the DOJ from withholding documents based on, quote, embarrassment, reputational harm, or political sensitivity, including to any government official, public figure, or foreign dignitary. This clause is crucial. Historically, the FBI and DOJ have used privacy as a shield to protect powerful politicians, senators, princes, CEOs, arguing that revealing their association with a criminal investigation would harm their reputation. The Transparency Act made that illegal. If a congressman was on the plane, the DOJ must release the record, regardless of whether it embarrasses them or ends their career. The act gave the DOJ a 30-day window. That is an incredibly tight deadline in bureaucratic terms, but it was intentional. Congress knew that if they gave the DOJ a year, the DOJ would take a decade. They gave them 30 days. President Trump signed it on November 19th, 2025. That set the deadline for December 19th, 2025. So what happened on December 19th? Silence. The DOJ released a pitiful batch of already public court documents, things we had already seen from the Ghislaine Maxwell trial, the real internal FBI files, the interview summaries, 302s, the surveillance logs from Epstein's properties, gone, withheld. And then came the letter. On January 6, 2026, ironically the anniversary of another chaotic day in history, Deputy Attorney General Todd Blanche sent a letter to the presiding judge and to Congress. In this letter, the DOJ didn't just apologize for the delay. They admitted to a procedural failure so massive it defies logic. They claimed that despite having decades to organize these files, they had suddenly identified over 5 million pages of records that needed review. Think about that. For years, the FBI claimed they had looked into Epstein. Now suddenly, when compelled by law to release the files, the pile of documents grows by millions of pages overnight. This is a classic document dump delay tactic. Flood the zone with so much material that you can claim it is physically impossible to review it all in time. But the most incriminating part isn't the volume. It's the refusal to provide the index. The act required the DOJ to provide an index of non-disclosure, a list of what they are holding back and why by that December deadline. They didn't do it. They are holding the files and the list of files. They are operating in total darkness, in direct violation of a law signed by the sitting president. Let's get into the weeds of the excuse, because this is where the admission becomes truly incriminating. The DOJ is claiming that they cannot release the files because they need to protect victim privacy. On the surface, that sounds noble. We all agree that the underage victims of Epstein's abuse should not be doxxed. The Transparency Act agrees with this. It allows for redactions of victim names and personally identifiable information. But the DOJ is using victim privacy as a Trojan horse. In their January filings, the DOJ lawyers argued that they need to redact information to protect unindicted third parties. In legal speak, an unindicted third party is anyone mentioned in a criminal file who wasn't charged with a crime. In the context of the Epstein case, who are the unindicted third parties? They aren't just the girls, they are the men, they are the clients. They are the people who flew on the Lolita Express but weren't charged by the corrupted prosecutors in 2008 or 2019. By asserting a broad privacy interest for unindicted third parties, the Trump DOJ is effectively arguing that they can redact the names of the powerful men who visited the island simply because those men were never charged. This is a direct violation of the Act's prohibition on redactions for reputational harm. If Bill Clinton or a Saudi prince or, yes, Donald Trump appears in an FBI interview summary as being present at a dinner with Epstein, that is not a victim privacy issue. That is a matter of public interest. Yet, the DOJ is currently applying a presumption of privacy to these names. Representative Thomas Massie went on the warpath this week. He tweeted, "The DOJ is asserting common law privileges that the Act does not permit." What does that mean? Common law privileges include things like deliberative process privilege, the idea that the government can keep its internal memos secret so officials can speak freely. The Transparency Act was designed to pierce that veil. It demanded the release of internal DOJ communications regarding investigation decisions. Congress wanted to know why Alexander Acosta gave Epstein a sweetheart deal in 2008. They wanted to know why the FBI closed its probe in 2015. By asserting these privileges now, Attorney General Pam Bondi is essentially saying, we know Congress passed a law saying we can't hide this, but we're going to hide it anyway using the old rules. This is an admission of lawlessness. The executive branch is telling the legislative branch that they do not respect the statute. And remember, the head of the executive branch is Donald Trump. This raises the uncomfortable question. Is Pam Bondi going rogue, or is she following orders? If you think this is just bureaucratic incompetence, look at what happened on December 23, 2025. For a brief window, just a few hours, the DOJ uploaded a new batch of documents to their dedicated Epstein portal. Among them were flight logs and, crucially, photographs. One file, which was quickly downloaded by internet archivists and journalists before it vanished, appeared to show a photograph of Donald Trump on Jeffrey Epstein's private jet in the 1990s. We have known Trump flew on the plane. He has admitted it in the past, saying it was a lift from Palm Beach to New York. But seeing the photographic evidence in an official FBI release is different. It makes it visceral. It makes it real. And then, poof, it was gone. By the evening of December 23rd, the file was removed from the server. When journalists asked why, the DOJ issued a cryptic statement saying, photos and other materials will continue being reviewed and redacted consistent with the law in an abundance of caution. Abundance of caution? Or abundance of panic? This deletion is arguably an illegal act. Once a government record is published under a transparency law, retracting it because it looks bad for the president is the definition of political sensitivity. The exact thing the act forbids. Furthermore, on that same day, the DOJ released a bizarre disclaimer on their social media accounts. They stated that some of the newly released documents contained untrue and sensationalist claims made against President Trump that were submitted to the FBI right before the 2020 election. Think about how insane that is. The Department of Justice, an impartial law enforcement agency, is issuing press releases proactively debunking evidence in their own file dump before the public has even fully read it. They are acting as the president's defense attorney, not as the custodian of records. This connects directly to the technofog and MAGA-sphere narrative. Influencers have been claiming that the Epstein files are full of planted evidence by the deep state to frame Trump. By scrubbing the files and issuing these disclaimers, the DOJ is validating that conspiracy theory while simultaneously suppressing the actual evidence.